A few weeks ago, a young lady walked into my office with her baby. She had fled persecution and arrived at a Canadian airport seeking for protection. According to her, no one had explained to her in detail what needed to be done next. She had no idea how to do it. She just knew that she had only 15 days to submit a crucial document called the Basis of Claim Form. By the time she came to me, she had already received a notice that her claim had been declared abandoned. Now, this story is more common than you think, and that's the reason why I'm making this particular video. Hi there, welcome back to another episode of Briefs and Balance. If you're new here, my name is Lily. I am a Canadian immigration lawyer, founder and principal counsel at Lily Ninko Law. Above all, I identify as God's masterpiece. If you're new here, consider subscribing to this channel to stay in the know about Canadian immigration and the reality of balancing life in Canada. Today we are breaking down the Canadian refugee claim process, particularly the inland claim. Outland refugees follow an entirely different process, and by outland I mean seeking asylum from outside Canada. And by inland I mean seeking for protection while within Canada. In this video, we're going to cover everything from who qualifies as a refugee, where and how to make a claim, the strict timelines you must not ignore, every step you take from the moment you say, hey, I need protection, to the day you receive a decision from the refugee board, and then beyond. So this video is intended to be sort of an overall guide from A to Z. So I need to say this. This is going to be a lengthy video, so grab your notebook and a bottle of water. I have mine here, Andy. So grab yours because it's going to be a lengthy video. We're going to cover every single detail with regards to the refugee claim process in Canada. All right. Now, before getting into the crux of today's topic, be informed that this video is made for information and awareness purposes only and should not be considered as legal advice. If you need legal advice that's applicable to your personal circumstances, book a legal consultation with me. The link to book a consultation will be added to the description of this video, or better still, you can call the phone number that will be displayed on your screen or send an email to the email address displayed on your screen, and we are definitely going to be in touch. We will be more than happy to book you in for a legal consultation with me regarding your specific circumstances. Okay, without further ado, let's get into it. Who qualifies as a refugee in Canada? Who is a refugee, like legally speaking? Under Canadian Immigration and Refugee Protection Act, there are two main categories of people who may be granted refugee protection in Canada: the convention refugee and a person in need of protection. The first we will talk about is the convention refugee. And for reference, of course, you could refer to Section 96 of the Immigration and Refugee Protection Act. The convention refugees are people who are outside of their home country or the country they normally live in, and who have a well-founded fear of persecution based on one or more of the following 5 grounds. The grounds include race, religion, nationality, membership in a particular social group. For example, women facing gender-based violence, members of the LGBTQ community, and the 5th ground is political opinion. Now, the term well-founded fear means more than just being afraid. It has to be both subjective and objective. What do I mean by that? By subjective, you need to genuinely fear for your life or your freedom. And then objective means a reasonable person in your situation or in your circumstances would also fear returning to their home country. The second category of persons that qualify for a refugee protection is known as a person in need of protection or persons in need of protection. For reference, Section 97 of the Immigration and Refugee Protection Act. A person in need of protection is a separate category for people who may not meet the convention definition but would still be in danger if returned to their home country. And this applies where there is a risk to life, a risk of cruel and unusual treatment or punishment, or a danger of torture. This is as defined by the Convention Against Torture, right? And this protection doesn't require you to prove persecution based on the 5 grounds above. That's the 5 grounds that I just mentioned, right? You just need to prove that you personally would be at risk if returned to your home country. It is, however, important to note that not everyone is eligible. There are important exclusions and exceptions in refugee law, and here are some key ones. You may be ineligible or excluded if you've already been granted refugee protection in another country. For example, you're recognized a refugee in the US or the UK, right? That makes you ineligible. You've previously made a refugee claim in Canada that was refused, withdrawn, or abandoned. You've committed serious crimes or acts that contravene or violate international human rights or security. You've entered through the United States land border and you don't qualify for an exception under the Safe Third Country Agreement. If any of these apply to you specifically, you could be ineligible. Again, this does not exclude the fact that there could be exceptions. Now, I know some people may be wondering what this Safe Third Country Agreement is all about. Let's quickly throw some light on the agreement in question, the Safe Third Country Agreement. Under this agreement, most people who arrive in Canada via the Canada-US border, that's the land border, cannot make a refugee claim in Canada. Very high level, that's what it's about. There are, however, a few exceptions to this agreement. These exceptions include a situation where you have a qualifying family member in Canada, or if you have an accompanying minor, or if you have a valid visa or permit, of course a Canadian valid visa or permit, or if you're making your claim at an airport or a seaport, not a land border. These are the exceptions to the Safe Third Country Agreement. Now, I'm going to touch more on this agreement when we talk about inland claims and where you can file your claim. Okay, let's proceed. Staying hydrated. Note that it's not enough to say I'm in danger. You have to show that your fear fits within the legal framework, right? And that's where evidence, credibility, and legal representation become critical. In the next part of this video, I'll break down the different types of refugee claims and why understanding the difference between an inland and port of entry claims could be the most important decision you make. Now that you know who qualifies for protection, let's talk about how people actually make refugee claims in Canada. Broadly, there are 2 main categories of refugee claims: port of entry claims and inland claims. I'm going to begin with a port of entry claim or port of entry claims. These are made at the border, that's at the airport or upon arrival in Canada. For example, if you walk up to a Canada Border Services Agency officer, that's a CBSA officer at the airport, and say, hey, I'm here to claim asylum, you're making a port of entry claim. This is if you've not been admitted into Canada yet. If they've not told you, welcome to Canada yet, that is considered a port of entry claim. A CBSA officer will at that point conduct an eligibility interview right there or shortly after. If your claim is found eligible, you are going to receive a refugee claimant package and you'll be asked to submit your basis of claim form within 15 days. This basis of claim form is usually popularly known as your BOC. Your biometrics and medicals may also be scheduled soon after, if applicable, meaning if they are no longer valid or they have never been provided before. If you're subject to the Safe Third Country Agreement, you could be turned away at that point at the port of entry, unless there's an exception to this, unless you meet one of the exceptions, the narrow exceptions that I had mentioned, one of which is having a qualifying member, having an unaccompanying minor, or if you have a valid permit or visa to come into Canada, as a case may be. If any of these exceptions apply to your case, then you will not be returned instantly. But if you do not meet any of these exceptions and that Safe Third Country Agreement applies to you, if you're subject to the agreement, then you could be returned immediately from the port of entry without being admitted into Canada. Now, we are going to return to the port of entry claims briefly when we talk about airport claims. But again, our focus is on inland claims, which are often slightly misunderstood, I would say. Let's get to the elephant in the room, so to speak. Well, the crux of today's video. An inland claim. Inland claims are made by people who are already inside Canada, meaning that you've already been admitted into Canada, you are already on the Canadian territory. You may have entered on a visitor visa, on a study permit or student visa, or perhaps irregularly, but you're now physically in Canada and seeking protection. There are three main ways to make an inland claim. Number one, online via the IRCC portal. This is most common today. This is the go-to method for most claimants. You need to create an IRCC secure account if you do not have one yet. You're going to upload your identity documents, upload your BOC form, you're going to answer eligibility questions, submit your claim online. Once submitted, you'll receive an acknowledgement of claim, a summary of your application, a document request letter as applicable if you've not submitted all of your documents, of course, and eventually an appointment for your eligibility interview. We'll break down this entire flow in the next segment of this video. The second way to submit an inland refugee claim in Canada is at an IRCC office. That's in person. This is less common today, I would say, and only allowed in specific circumstances, such as if you're facing urgent removal or deportation, if you've been invited to appear in person for any reason at all, or if you're unable to submit a claim online due to personal circumstances. Appointments must be booked in advance, and walk-ins are rarely accepted. It's also used when a claimant needs help or is a claimant with different abilities. The third way to submit a claim in Canada would be at a port of entry, but which is processed as an inland claim, meaning that it's not recognized as a port of entry claim, but it's done at the airport, for example. Sometimes an individual enters Canada with a valid visa, meaning that they get admitted into Canada with a valid visa, but before leaving the airport or immediately afterward, they notify the border officers that they wish to claim asylum. This may be treated as an inland claim procedurally speaking, but it follows port of entry protocols, right? They're going to take you to speak with CBSA officers to sort of hear a little bit about your story and a little bit of eligibility questions here and there. However, this is classified as an inland claim because you were already admitted into Canada. And these cases carry, special attention, especially for compliance with the 15-day deadline to submit your BOC if that doesn't get done there and then. Regardless of where or how you make the claim, your timelines begin ticking immediately after eligibility is determined. Many claims get into trouble due to missed deadlines, poor document management, or not understanding or misinterpreting the entire procedural requirement or the entire process. That's why in the next section of this video, we're going to be diving into how to properly file an inland refugee claim in Canada, step by step, with timelines and practical tips you won't want to miss. Now, if you've watched up until this point, this is the right time to click a like button if you find this video informative or helpful in any way, and consider subscribing, because on here we share briefs about Canadian immigration and about balancing life in Canada. And if you like what you see and would like to know more, don't hesitate to drop a comment under this video letting me know what you'd like to hear me talk about next. Thank you. Let's proceed and talk about how to file an inland refugee claim in Canada. Now, whether you're fleeing political persecution, gender-based violence, or targeted threats because of who you are, you must understand that how you initiate your claim in Canada affects everything that follows. Let's take a deep dive into the three main channels for filing an inland claim and the procedural nuances of each. Okay, claiming asylum at the airport, popularly known as the port of entry claim. Imagine this: you land at the Pearson International Airport, and at the CBSA booth, the officer asks, "What's the purpose of your visit?" You respond, "I'm here to seek asylum." From that moment, the legal machinery starts turning. Here's what happens next. you're immediately referred to a CBSA officer who is going to conduct a preliminary eligibility interview, so to speak. You may be given an information package. You're going to be asked questions, of course, about the circumstances surrounding your trip to Canada and how you obtained your visa. They're going to ask you some questions. Not to scare you, it's not going to be I can't guarantee that it's not going to be a lot of questions, but expect the questions. It's an interview, for crying out loud, right? And then you're potentially going to be given a basis of claim form or instructions on how to complete it online. You're going to be given a conditional departure order, which becomes relevant if your claim is denied later on, meaning that the removal order or deportation order is not valid until something happens to your claim. For instance, your claim gets initially refused or anything like that, then that departure order or removal order or deportation order, whatever it is that it's termed at that time, would become enforceable. Now, you will not be granted immediate protection. Okay, you must know this. You have to prove your eligibility and meet statutory requirements. However, depending on your circumstances, you could be asked to, go to wherever you're planning to stay, or you could be referred to a shelter, or if there are any sort of complications at the airport regarding your identity or criminal admissibility, medical inadmissibility, or any of those types of complications, you could be detained in an immigration detention center from the airport. One very important aspect of this process is you have 15 days. I can't stress this enough. You have 15 days to submit your BOC form. If you miss this deadline, your claim could be declared abandoned, even if you're still in Canada. Risks of getting incarcerated in an immigration detention facility are higher when your circumstances start getting complicated with identity issues. For example, coming in with a different name, different passport, different date of birth, or misaligned or conflicting identity information. So those types of complications could expose you to the risk of getting incarcerated, meaning that getting detained in an immigration detention facility. Now, here is a tip for you. If you are considering making a claim at the airport, always ask for written confirmation of timelines before you leave the airport. Don't just relax. I strongly recommend you call a lawyer immediately. Speak to someone who could help you get in touch with a lawyer immediately you leave the airport. Now, let's talk about submitting a claim online. Claiming online via the IRCC portal is the most common route these days, and equally the most misunderstood. This is the standard pathway for most refugee claimants who are already inside Canada. And here's how it works. I'm going to break it down in 2 steps. Step 1 would be to create a refugee claimant profile. So you go to IRCC, the IRCC portal, you create a secure account if you do not have one already. If you have one already, you could just create your claim from within your IRCC account. Now, once you create your account, you complete the eligibility questionnaire, you upload your basic identity documents, meaning your passport, ID, birth certificate, visa if any, and your BOC form plus your narrative. So there's a way to organize all of these documents. Find legal representation to assist you with organizing these documents before submitting. It's crucial. Once you've gathered all of your documents, step 2 would be to submit the claim, right? And these documents in question include your basic biodata, reasons for claiming protection, and supporting documentation. Once you submit your claim online, you're going to receive a submission confirmation, which includes the summary of your application. You're equally going to receive an acknowledgement of your claim letter, instructions to complete biometrics and medical exams as applicable. You're going to equally receive a letter requesting additional documentation if applicable. The third step would be to wait for your eligibility appointment. You'll be called to appear before an IRCC officer, and your identity, documents, and background will be assessed. If eligible, you'll receive your confirmation of eligibility, your refugee protection identity document, and your work permit as applicable, and a conditional removal order, which is only enforceable if your claim gets refused down the line. Following this interview, if you are eligible, your claim will be referred to the Immigration and Refugee Board, and you will receive a confirmation of referral to the Refugee Protection Division of the Immigration and Refugee Board in your online portal. Mind you, many claimants upload incomplete or inconsistent information. You need to be mindful of all the information you submit, because once submitted, your story is on record. Changing it later can affect your credibility. Next, let's talk about submitting your claim at an IRCC office. Claiming at an IRCC office is not available to everyone as of recent times. You must book an appointment through the IRCC Client Support Center. You must provide a reason why you cannot file online, which could include different abilities, challenges, language barriers, computer illiteracy, or imminent removal, as the case may be. At the IRCC office, you'll meet with an officer in person. They'll review your documents, conduct the eligibility assessment, and if eligible, you'll receive your referral documents and instructions to complete the BOC form. That is, if it's not done at that appointment. In recent times, IRCC in-person claims are relatively rare and usually done in consultation with legal counsel or a caseworker, as the case may be. Now, I can't stress this enough. Always consult a lawyer before walking into an IRCC office. Whatever it is that's taking you to an IRCC office, do not go there without consulting a lawyer. Now, we've discussed the different ways you can submit your claim, and here are a few takeaways. Regardless of how you file your claim, you must keep all communication received from IRCC or CBSA. You must write down your deadlines, especially the 15-day BOC deadline. You must attend all your appointments, or you reschedule them with notice. You must keep your lawyer informed and updated of any information from your address, phone number, everything really with regards to your circumstances. Ensure that you keep your lawyer, IRCC, and IRB informed as applicable. Now that your claim is submitted, you might think the hard part is over, right? But it's only the beginning. Now we're going to talk about why it's absolutely essential to have a legal representative and how one wrong move can derail your entire process. This is why you need a legal representative in your refugee claim. A refugee claim is not a DIY project. That is why legal help is critical. When it comes to refugee claims, the law is complex. The procedures are strict and the stakes, nothing short of life or death immigration law speaking, right? Let me be clear. You're not required to have a lawyer to make a refugee claim in Canada, but attempting to navigate this process without proper legal guidance is like walking through a minefield blindfolded. It is a risk that's not worth taking, if you ask me. I mean, you have, the discretion or the liberty to make your choice and submit your claim by yourself, but it's not recommended, it's not advised. Ensure that you have legal representation, or at least someone who could view your application from a legal lens. Refugee law is not ordinary common sense. It is legal strategy. Most claimants think it's enough to say, hey, I'm abused, or I'm scared to return to my home country. But the Immigration and Refugee Act doesn't operate on sympathy. It operates on legal definitions, evidentiary thresholds, and credibility assessments. You need to ensure that your story is presented in a credible manner, because mere confusion or trauma could derail your entire process, not because you're not telling the truth, just because of lack of strategy. A qualified immigration lawyer helps you present your story within the correct legal grounds, which include race, political opinion, social group, and as applicable with regards to any of the grounds. The lawyer or a qualified immigration lawyer helps you avoid pitfalls like irrelevant details or emotional narratives that lack legal essence or legal value. A lawyer would identify risks of exclusion or inadmissibility before you even submit your claim. The second point that's crucial that needs to be taken into consideration whether or not to retain a lawyer on your refugee claim is your BOC form, which can make or break your claim. The BOC form is the foundation of your entire case. What you say, or fail to say, whatever you enter or fail to enter in your BOC form can follow you through your hearing, every appeal, every judicial review, all the way to a final decision on your claim. So it's critical to ensure that a lawyer helps you or guides you through filling out your BOC form. A lawyer will help you fill out the information clearly, consistently, and credibly, and ensure all relevant facts are included, not just what you remember under stress, right? A lawyer would guide you, ask you the right questions to ensure that the right information is entered in your BOC form. Also, the lawyer would help cross-reference your narrative with country conditions and legal arguments to ensure that you're putting a best foot forward. One thing that I must mention is I've seen a lot of claimants who lose at their hearings, at their initial hearings, because of contradictions or inconsistencies between their BOC and later testimony. So it's important and crucial for you to avoid this trap. Also, your lawyer thinks 10 steps ahead of the process, right? Just because immigration lawyers are trained to track your timelines and ensure no step is missed, prepare and file evidence in accordance with Immigration and Refugee Board rules, which is usually 10 days before the date scheduled for your hearing. And they're trained to anticipate questions from the IRB member and prepare you accordingly. And that includes advocating for procedural accommodations, for example, trauma-informed hearings, language support, remote testimony, as the case may be. We as immigration lawyers don't just fill out forms. We review your narrative and advise on its potential to undergo legal scrutiny. An important aspect to mention is communication. When you hire a lawyer, your refugee claim does not become a one-way street. As a claimant, you must respond promptly to your lawyer's emails and calls, provide accurate and complete information, let your counsel know of any changes. As I mentioned, your address, health, emergency, family status, keep your documents organized and secure. Many cases fall apart not because the lawyer failed, but because the claimant disappeared or delayed, or there could have been a breakdown in communication between the lawyer and the claimant. Try your best to stay in touch with your lawyer or your legal representative. If you're asking yourself whether or not you can afford the services of a lawyer, if you're unsure, listen to this. Legal aid and pro bono service do exist in Canada. So don't let money stop you. In most provinces, including Ontario, legal aid may cover the cost of legal representation for eligible refugee claimants. You may also find pro bono lawyers, refugee law clinics, community-based support centers who could refer you to pro bono lawyers. And all of these resources are available. You just need to do some research or speak with the right people, and you are going to have access to these services or resources. Well, in all that you do, don't make the mistake of thinking that, I'll just do it myself and then I'm going to get help later on. In refugee law, later on may be too late. Some of the most heartbreaking consultations I've had were with people who tried to figure it out themselves, only to return months or a few years later after their claims were refused or declared abandoned. That you do not want to find yourself in such circumstances. So hear me now. If you're considering or are in the middle of a refugee claim, retain legal counsel as early as possible. It can mean the difference between protection and removal. This is crucial. If you're already in a similar situation where you represented yourself and would like to know the way forward, book a consultation with me and we'll go over the details of your claim, and I'll provide you with legal advice tailored to your situation. Or if you just need a legal opinion, I can certainly do that as well. Now that you understand how critical it is to get legal guidance, let's move into the nuts and bolts of the process, the timelines, the appointments, the government letters, the IRB notices. Because yes, there is a process, and it's far more structured than most people realize. It is important for you to save every single letter you receive from IRCC via your IRCC portal. Keep the digital and printed copies if possible. And if there are any changes to your address, phone number, or email, notify your lawyer, IRCC, and IRB immediately. The next step would be the biometrics appointment, fingerprinting, and photos. If they've not been provided yet. If they've been provided yet, then you can definitely skip this step. You'll be scheduled to attend a biometrics appointment at a Service Canada location, and this is usually done by sending you a letter requesting for your biometrics, and the deadline to get this done is 30 days of receiving that letter, that instructions letter. And then you're expected to bring your passport, the letter in question, the appointment letter, and any other ID. And so once this is completed, you will routinely call a Service Canada location that provides the biometric service, book your appointment, and get this completed. The deadline to do this is usually 30 days from the date of the letter, the date written on the letter. Failure to complete this step can stall or suspend your claim. It may cause delays also. Next is the medical examination. If you have valid medical exams still on file, fine, you could potentially skip this step. However, if it's been more than 3 months since you completed an immigration medical examination, you'll be instructed to complete a medical exam with a panel physician approved by IRCC. The deadline for this step is often within 30 days from the date of the letter. Again, ensure that the medical exam is completed within 30 days. You do not want to delay your refugee claim process, right? So complete it as soon as possible after receiving the letter. This medical examination is not a test of fitness, so to speak. IRCC is known to screen for public health risks, for example, tuberculosis or any other major disease or condition that could potentially render you medically inadmissible. Refugee claimants are eligible for coverage through the Interim Federal Health Program, IFHP. And it is important that when booking your appointment, ensure your panel physician accepts IFHP before scheduling your appointment. What this means is if the physician accepts IFHP, you won't be paying for the medical exam out of pocket because you sort of have that coverage. Next, the eligibility interview. Your eligibility interview could be in person, more than likely, especially in recent times, at an IRCC office. This is usually conducted with an IRCC or CBSA officer, as the case may be. And this is where your identity is confirmed, your documents are reviewed, you are officially referred to the Refugee Protection Division of the Immigration and Refugee Board, either on that day or shortly after. You could be handed your work permit as well at this appointment, if you applied for it, of course, while submitting your application for refugee protection. And you will be given a conditional removal order. I already explained what that is. Following this eligibility interview, you are going to receive a confirmation of referral to the Immigration and Refugee Board. This usually gets sent to your IRCC portal. Your hearing date would potentially follow, or a notice that a hearing will be scheduled will be sent to your IRCC portal. Mind you, your hearing could be in 60 days, as it's said in the regulations, or it could be 6 months, or even longer, or even later down the line, depending on a few factors: the region where you submitted your claim, the backlog of the Immigration and Refugee Board, and your claim type. I hear people say this a lot: I submitted my claim, it's been more than a year, I haven't gotten a hearing date, my lawyer isn't taking it seriously, my lawyer is not doing anything about this delay, I'm frustrated, it's such a long time to wait. So many things around timelines. Nobody, in terms of immigration lawyers or immigration practitioners or legal representatives, has control of timelines. The Immigration Board is backlogged, believe you me. So what I can advise is keep checking your emails and your mails, of course, and ensure that you put your notification on for your email account that's associated or linked to your IRCC account, just so that you stay in the know whenever you get a notification from your IRCC account. You do not want to miss an important notification from IRCC. Next, let's talk about the BOC. The BOC, the Basis of Claim Form, is the most critical document you complete as a refugee claimant. The deadline to fill this form, as I mentioned, is 15 days from the date you were found eligible. That's if it was done at a port of entry or at the airport. If you submitted your claim online, it is due before you can even proceed with clicking submit, because it's one of the required documents. So it is due before you can successfully submit your application. The content of the BOC form is a detailed narrative of your story, detailing the risk of persecution you face, your background, family information, travel history, and your personal biodata. That's your name, date of birth, and identity information. Think of the BOC as your legal voice, that thing that tells your story. It must be detailed as possible. It must be consistent and complete. Always draft your BOC form with your lawyer or your legal representative, and do not rush this step. If you have retained legal counsel or legal representative or an immigration lawyer for your refugee process, do not rush the step of filling up your BOC form. You want to ensure that it is done with adequate time and attention. Next, let's talk about preparing and submitting evidence. Once you are referred to the Immigration and Refugee Board, you must prepare for your hearing by gathering supporting evidence, supporting documentation to support your claim. Supporting documents or evidence could include country conditions report, human rights publications, news articles, affidavits from family or witnesses, photos, hospital reports, videos, police statements, hospital statements, and any documentation really that would support your claim. The deadline to submit evidence is at least 10 days prior to your hearing date, 10 days before your hearing date. So the moment you get a hearing date, keep in mind that 10 days before that date is the last day to submit your evidence or supporting documentation. I say this because late evidence is often rejected unless exceptional circumstances are proven. So keep it in mind. You do not want to get caught up in a whole situation where you do not only have to prove your claim or defend yourself, you need to explain why your evidence is late. Just act fast and act in time. Yeah. Okay, next. Pre-hearing conferences. These are really rare, I would say, especially in recent times. These are not mandatory in all cases, but IRB may schedule a conference, a scheduling conference, or credibility issue conference, vulnerability accommodation conference, and this is usually an opportunity to request for interpretation services, notify the IRB of trauma, PTSD, or any needs for hearing accommodations, and clarify legal issues that may affect your hearing, how your hearing is conducted. Again, these conferences are not mandatory and do not occur in all cases. Next, let's talk about your big day, the refugee hearing. The refugee hearing is not a mandatory step, meaning that there are refugee claimants who have obtained protected person status or convention refugee status without necessarily going through the step of a refugee claim hearing. So if this step applies to you, listen up. You will be expected to attend your hearing before a member of the Refugee Protection Division, and here's what to expect. Your lawyer or legal representative will accompany you, meaning they will be with you during that meeting. Could be virtual or in person down the line, I'm not sure, but currently it's still virtual. And an interpreter will equally assist if needed. The IRB member will ask questions about your BOC, your documents, and your credibility and identity as the case may be. You'll be asked to testify and explain why you're here returning home, and the hearing may last 2 to 4 hours or be adjourned if more evidence is required. On the day of your hearing, the hearing is going to begin with an officer ensuring that the logistics are taken care of. The role of this officer is to ensure that everyone is successfully connected to the meeting if this is happening virtually. The officer would equally ensure that if there is an interpreter, that the claimant, the lawyer, and everyone else on the call is able to hear and understand the interpreter, and vice versa. Once all of the logistics are all completed and the Immigration and Refugee Board member joins the call, you'd be expected to identify yourself again on record. So you're going to state your name, your lawyer is going to do the same, and the board member is going to do the same as well. You'd be expected to confirm that nobody can see or hear you during the hearing. Same thing with your lawyer, and same thing with the member. And so before this hearing begins, you have the last opportunity, so to speak, to make any changes to your documents, your BOC form, your narrative, everything that you've submitted before the board. This is your last opportunity to make any changes. And the board member will expressly ask if there are any changes that you need to make. Is going to confirm all of the documents that you've submitted thus far. And if you say no additional documents to be submitted, no changes, we can proceed, then fine, the board member is going to proceed. But if there are any changes, if for example you made a mistake in your BOC form and then you remembered just before the hearing, this is a time to say so, because once the hearing begins, all of the assessment and the decision is going to be based off of everything that you've submitted up until this point. That said, once all of that is out of the way, the hearing is going to begin. So during the hearing, the refugee board member could be looking to confirm your identity if they have any discrepancies that have been identified or conflicting information that has been identified around your identity or around your credibility in general. So expect a lot of questions from the refugee board member to establish your identity, your credibility, and the basis of your claim in the real sense of it. You will be asked to testify and explain why you fear returning to your home country. And if you're someone who has had to visit other countries prior to Canada, especially on your way to Canada or shortly before making your refugee claim, expect a lot of questions around the reason why you did not seek for protection in another country and chose Canada. The hearing may last 2 to 4 hours or be adjourned if more evidence is required or if there are more questions that the refugee board member has for you. At the end of the hearing, the refugee board member may issue a decision orally or reserve their decision and issue it in writing weeks later. Listen, this hearing is your moment. Be truthful, be calm, and remember that you should be consistent. You need to be audible and clear in your testimony. You need to ensure that you can hear everyone and everyone can hear you loud and clear. Now, if you do not understand any question, feel free to ask the person who asked the question to paraphrase or ask the question differently. Feel free to say that you did not understand a question, because it's one thing to provide a wrong answer to a question, and it's another thing to provide the right answer to the wrong question, meaning that it could be asking question A and then you give the correct answer to question B. So if you do not understand a question, or if you have any doubts with regards to the information that the board member is looking for or that your lawyer is looking for, whoever is asking the question, ensure that you say so. Clearly state that you do not understand the question. Ensure that your mic, your device, whatever you're using during the hearing is functional and works well. Ensure this even prior to the hearing, because you do not want to face tech issues during your hearing. Now let's talk about what happens after the hearing. This is when, after the hearing, of course, when you're waiting for the decision. If you did not get a decision right away, or if you got the oral decision and of course you're waiting for the written decision, you're going to receive a written decision if, of course, your hearing was completed and then the member mentioned that they're going to reserve their decision and then issue it in writing. Or if the hearing did not come to an end, it was adjourned, then expect another hearing date. But if everything was done and then the member says they reserve their decision and will issue it in writing, you are going to receive a written decision, which could either be positive or negative. Now, a positive decision is one that would declare you a protected person or a conventional refugee, as the case may be, and then enables you apply for permanent residence in Canada. A negative decision, on the other hand, comes with the finding that your claim is either not credible or lacks any credible basis, or for a reason or two, you are not considered to be a person in need of protection, or you're not a protected person. Now, if you receive a negative decision, you're going to be given reasons for the refusal, and you're equally going to have options to appeal the decision or seek judicial review, as the case may be. One very important thing that I need to mention here is, even after a positive decision, do not travel to your country of origin yet. Whatever the case may be, emergency or not. I'm sorry if this sounds insensitive, but whatever the situation is, do not return to your home country immediately after a positive decision. You're not there yet. You risk nullifying your protection altogether. Next, let's cover what happens after you get a decision, including the path to permanent residence and your legal options if your claim is refused. So you've had your hearing before the Refugee Protection Division. You've testified, you've waited, now the decision is in. Let's explore both outcomes and the different roads that follow. If you receive a positive decision, you are now a protected person or a convention refugee, as the case may be. Congratulations to you. The RPD has accepted your claim. You are now legally recognized as a convention refugee or a protected person. Here's what that means. You can now apply for permanent residence in Canada, meaning that you are eligible to submit a PR application under the Protected Persons and Convention Refugees in Canada class. You will be applying using, of course, Form IMM 008, and you include family members who are in Canada with you or outside Canada if they were listed in your original claim and meet IRCC's criteria. In terms of timelines, I recommend you apply as soon as possible after the positive decision. You do not want to take any risks, right? Apply as soon as possible after a positive decision. I recommend you apply for PR as soon as possible because delay could raise complications. You do not want any sort of complications in your matter. I'm not trying to sound negative, but there could be complications that could, be raised, especially if your country conditions change or family situations evolve. You never know. Okay, so apply for PR ASAP. Let me reiterate the things that you cannot do after a positive decision. Do not return to your country of origin, even for a funeral or family emergency. Sorry if that sounds insensitive, but it's not advised. Doing so may trigger a cessation application and lead to loss of refugee status. Do not use your home country's passport to travel. Generally, that passport would have been either taken away from you, or if maybe you lost it and then later found it and you're still in possession of it, do not use that passport. Using it simply means you're reavailing yourself to that country, meaning you're still presenting yourself as a citizen of that country, right? So if you have to travel after a positive decision from the Immigration and Refugee Board, I suggest you apply for a refugee travel document instead. Mind you, you're still vulnerable to cessation or vacation proceedings until you become a Canadian citizen. Remain in compliance, maintain accurate records, and never travel to your home country of persecution if you've not obtained your Canadian citizenship yet. I say never just to be on the safe side, but again, exceptions could apply with a lot of litigation surrounding it as well. Just keep that in mind and make the decision based on your willingness and your ability to engage in all of those battles all over again. If you receive a negative decision from the board, the road is not over yet, but it just got slightly harder. I know that a refusal stings really hard, but it's not necessarily the end. There are several legal pathways that are still available depending on your specific situation. The first could be an appeal before the Refugee Appeal Division. That's RAD. If you're eligible, you can file for an appeal with the Refugee Appeal Division, and the deadline is 15 days. I believe you have 15 days to file a notice of appeal and 30 days to perfect that appeal, meaning to submit your full appeal record. You should not do this by yourself. Seek legal counsel. In your appeal record, you or your lawyer in this case can raise legal errors as applicable, misinterpretation of facts, procedural unfairness as applicable. Once you file an appeal before the RAD can either overturn the decision made by the RPD, order a new hearing, or uphold the original ruling. Not everyone is eligible to appeal an RPD decision before the RAD. You cannot appeal to the RAD if you are a designated foreign national, you came through the US border, had a prior claim and had a prior claim that got rejected on no credible basis, your claim was withdrawn or abandoned, or for some reason your claim was declared abandoned. These are circumstances under which you do not have the option or the luxury of applying for an appeal before the Refugee Appeal Division. If you're not eligible to appeal the decision before the RAD, it's not over for you yet. There is another pathway that could be available to you, which is the judicial review at the federal court. If you're eligible for RAD, your RAD appeal, and your RAD appeal is unsuccessful, you may equally seek leave for judicial review before the federal court. This involves you filing an application for leave within 15 days, receiving the written decisions, and if leave is granted, a federal court judge will review the legality of your RPD decision. The judge may not grant you protection right away, but they can order a new hearing if an error is found. Mind you, judicial reviews are paper-based and highly and crucially technical. This is not a second chance to argue your case emotionally. It is legal argument. A skilled immigration lawyer is essential here. I can't stress this enough. The third pathway after a refusal from the Refugee Protection Division would be a pre-removal risk assessment, popularly known as PRA. If you are facing removal, you may be eligible to apply for PRA. This is usually referred to as your last chance to argue that returning to your home country would expose you to risk. The PRA application considers new risks that weren't discussed or addressed before. That's before the RPD or the RAD as applicable. Changes in country conditions, danger to life, or risk of cruel treatment or torture, as the case may be. Not all claimants are eligible for PRA immediately after refusal. It depends on your procedural history. Keep that in mind. Again, that's the reason why all of the information shared in this video is really information, okay, just for awareness purposes. And do not consider this as legal advice, because every story or every case is unique. If you need legal advice, seek legal advice. Book a consultation with me by clicking the link in the description, and I'll be able to provide you tailored advice, customized and tailored to your need. The fourth pathway you can explore after a refusal is the Humanitarian and Compassionate Grounds application, popularly known as H&C. If you've established ties in Canada, you have children, or suffer from a medical or personal hardship, and you have basically built a life in Canada, an H&C application might be a viable path for you. The H&C application is not an appeal of your refugee decision. It's a discretionary request for permanent residence based on humanitarian factors. The processing time is long and approval is not guaranteed. As of July 2025, the processing time is 24 months for a humanitarian and compassionate grounds application. The fifth pathway you can explore after a refusal, especially if you are facing removal, would be a deferral request. So, if CBSA issues you a removal order, take action immediately. Do not sit on it. Take action immediately. You may be able to request a deferral of your removal or a stay of your removal through the federal court, as the case may be, or intervention by a member of parliament in rare humanitarian cases. Do not ignore removal notices. Do not go underground, as you usually see it. The legal consequences of going underground are severe. Do not attempt it. Act immediately. Speak with a lawyer and get something done ASAP. One important takeaway that you need to note from this video is you need to act quickly and strategically after a negative decision. Timelines are extremely short, and delay can cost you your legal rights. Even if your claim is refused, you are not powerless, but you need help. Now let's talk about the most common reasons why some refugee claims fail and how you or someone you care about can avoid these traps. The first is missing deadlines or timelines. This is the silent killer of refugee claims in Canada, because time is really not on your side. And here are some of the most commonly missed deadlines. The BOC Form not submitted within 15 days after referral, evidence not submitted within 10 days prior to the hearing date, the RAD appeal not filed within 15 days after receiving a negative decision in writing, Judicial review not filed in 15 days after receiving the decision in writing. Failure to attend biometrics or medical appointments on time. All of these are deadlines that, when missed, could silently kill a refugee claim or make it unnecessarily complex. A missed deadline doesn't just cause a delay, it can lead to a claim being declared abandoned with no second chances. Be very mindful of these deadlines. Do what you need to do. If you need to put reminders or notifications on your phone, do that. If you need to do so on your computer, do that. If you need to tell a close loved one to remind you of these deadlines, please do that. At every stage of your claim, keep a timeline tracker or calendar or reminder, and share deadlines with your lawyer or sponsor, whoever is assisting you in this process. And if you are in doubt, don't hesitate to ask. You can always ask another lawyer or an immigration lawyer or a legal representative. You can always seek for independent legal advice. Do not refrain from asking questions if you have any sort of doubts. Reach out to your lawyer prior to the deadlines. Check your emails for any notifications. Again, turn on notifications on your phone for emails. That way you stay tuned. The next pitfall is inconsistency. Inconsistent statements around your claim. Credibility, like I always say, is everything when it comes to a refugee claim in Canada. Refugee claims rise and fall on credibility. If, for example, your BOC says you were arrested in June, but you testify it happened in September, or if you say you were in hiding and you had no access to any electronics in the month of February, for example, but your WhatsApp or Facebook Messenger, whatever it is, was active, daily in your home city, there could be a credibility finding. If you say you've cut ties with your home country, but you used their passport last month, for example, prior to your hearing, that's another issue, credibility finding. These things may be fatal to your claim. As funny as they may sound, and I mean, for someone who's cool, or for someone who's familiar with these things, it could sound ridiculous. Like, how could you do that? Like, what's that? Truth be told, some people are not aware of these things. So that's why we do what we do. We try our best to put out information out there, create awareness, because some people genuinely do not know these things and do not know the impact that they may have in the refugee claim. Such credibility findings could be fatal to your claim, especially when the IRB member suspects that you're not telling the truth. It just taints your credibility altogether. And remember, the IRB doesn't just look at whether your story is sad enough or pathetic enough. They assess whether it is consistent, whether it is plausible and supported by evidence. So the moment your story or your narrative does not stand this test, welcome to a potential negative decision. You have to be mindful. The next pitfall is poor documentation or no documentation at all. Not every refugee, has documentation, granted, and even the IRB knows this. But when documents are available and not supported and not submitted properly, it raises flags. Some common issues could include forged or altered documents that could lead to instant credibility collapse. Evidence submitted too late or in the wrong format that could cause delays or hiccups in your hearing or in your entire process. You do not want that. No explanation for missing key documents or missing key information like police reports, arrests, medical reports or medical records, and so on and so forth. If you mention all of these in your narrative and then these documents are not there to corroborate what you said in your narrative, that could negatively impact your claim. If you are unable to obtain documents, understandable, just ensure that you explain why in a written statement. Silence could invite suspicion. The fourth pitfall is updating contact information. Listen, this may sound as minute as you can imagine. However, it is a common and devastating oversight. Believe me, if you change your phone number, you move houses or apartments, whatever it is, you lose access to your email and you don't inform the IRB or IRCC, you may miss critical You may miss critical letters about your hearing date, your biometrics appointment, your medical examination appointments, your removal notice, and important deadlines. Really, it is critical, and the moment you miss any of this, you could miss a critical deadline that could lead to your claim being declared abandoned. That's a whole other complexity on its own. Mind you, the IRB is not responsible for your mail delivery. You are. Always notify the IRCC and IRB of changes using official forms, could be web forms, whatever it is. Speak with your lawyer and they would know exactly what to do. The next pitfall is poor communication with your lawyer. Legal representation is powerful if you use it properly. Problems could arise when you disappear between appointments, you fail to send documents, you withhold important information or important facts because you're ashamed or you're scared. I mean, lawyers can help you if they know the full truth early, and that includes past immigration history. Yes, even that US visa refusal or that US visa or UK visa approval, whatever it is. Tell your lawyer about it. Criminal charges, even if they're dropped, previous claims or deportations in other countries, whatever it is, just speak to your lawyer about it. We've seen cases collapse because claimants thought, oh, maybe they won't find out. You can't assume that. You cannot. We've seen cases where claimants think the information that they submitted during their visa application would not be brought up during the hearing. Excuse you? The IRB has access to all of this information. The IRB and IRCC could have access to any immigration-related information across the world. There's such a thing as forensic reports. They could have these superpowers. It's important for you to disclose this information to your lawyer, and your lawyer would know exactly what to do with this information. You do not want to get startled during your hearing with information that you had never disclosed to your lawyer or to IRB or IRCC. You put yourself in a precarious situation. You put your lawyer in a delicate situation. And that's a big hello to a negative decision, depending on the gravity of the information in question. Be mindful. And listen, they will find out, okay? They definitely will find out. It's just better if it comes from you. So just be upfront and be open about it. Just provide this information to your lawyer. The next pitfall is social media related inconsistencies. Digital evidence. The silent witness. I call this the silent witness. Yes, IRB members and CBSA officers may review digital footprint. Yes, IRB members and CBSA officers may review your digital footprints. If you say, for example, you cut ties with your home country, but your TikTok says, or your TikTok, Instagram, Facebook says, hey, coming home soon, team 237 or team 234 or team whatever. Coming home soon, home is home, home sweet home. Listen, if your LinkedIn, for example, lists you as working in XYZ company after you claim to be in hiding, or if you post selfies from a protest you deny attending, all of these things could have, impactful consequences, right? And they could be used to discredit your claim. Sadly so. You need to be mindful. And you need to keep your online presence consistent with your claim. I am by no means saying you should delete your social media. That's not what I'm trying to say here. All I'm saying is you should ensure that your social media is consistent with your claim. Ask your lawyer to review anything questionable, okay? Seek legal advice. The next pitfall is abandonment or withdrawal. These are two different things, and it's important to know the difference. A claim is abandoned or deemed abandoned when you fail to take required steps. For example, missing the BOC deadline, that's not providing the BOC within the required timelines, skipping your hearing without notice or any notification from either you or your lawyer. On the other hand, a claim is withdrawn when you voluntarily end your process. In both cases, you may be barred from making another refugee claim in Canada, as the case may be again. Always speak with a lawyer before taking or failing to take any action. it's important. Let me remind you, the refugee process sometimes is not forgiving. Canada offers, fair processes with regards to refugees, but not infinite chances. One misstep may cost you your protection. That's why being prepared, being honest, and being timely are not optional. They are essential. Your claim has now been accepted. You're now a protected person in Canada, or a convention refugee. Let's discuss this. Who is a protected person in Canada? This means that you're now legally recognized as a convention refugee or a protected person according to Canada's immigration legislation, and this status shields you from deportation, affirms your legal right to remain in Canada, and makes you eligible to apply for permanent residence in Canada. Protected persons must apply for permanent residence through a specific stream called Protected Persons and Convention Refugees in Canada class. And here's what you need for your permanent residence application as a convention refugee or protected person. First is your form IMM 0008. That's the generic application for permanent residence. Your Schedule A, that's your background and declaration. Your Schedule 12, that's additional information. That's for refugee claimants in Canada specifically. You're going to need your identity documents, of course. That's your passport, refugee document, IRB decision, any identity document that you have and that you've submitted, of course. You're going to need your biometrics and medicals, as the case may be, which could be reassessed depending on timeline, meaning that if they're expired, you'd have to do them again. In your permanent residence application, you can also include your spouse and dependent children, whether they are in Canada or abroad, if you declared them at the initiation of your claim. And IRCC will conduct, background and security checks, and they must undergo medical examinations as well. And IRCC will issue visas to reunite them with you. That's upon approval, upon PR approval. This is worth noting. Failure to declare family members can lead to lifetime bans on sponsoring them later, as the case may be, and therefore it's recommended to be transparent, even if the relationships are strained, right? Be very cautious of the information that you provide with regards to your dependents. Next, travel restrictions. Travel restrictions still apply even after being accepted as a protected person. Like I mentioned, do not travel to your country of origin, do not use your home country's passport. Exceptions do apply, so seek legal advice. Instead of using your home country passport, I recommend applying for a refugee travel document through the IRCC portal, like I mentioned. This document allows you to travel internationally to countries that accept the Canadian travel document in place of a passport. You could travel to these countries and any other country except to your country of persecution. I say this because returning to your home country physically or politically, however you want to put it, can result in cessation proceedings, loss of protected status, revocation of PR if it's been granted already, and removal from Canada depending on the circumstances. The repercussions or consequences are severe. Ensure that you avoid the risk altogether. Until you are a Canadian citizen, your status remains conditional on continued risk. Guard it carefully. Next, let's talk about work and study rights after a positive decision. As a protected person, you may continue working or studying in Canada. You could extend your open work permit if needed while your PR is in process. You could access provincial services such as healthcare, education, and settlement programs, do some research, ask questions, ask around. Some provinces may also offer, tuition support or PR in process health benefits, and therefore I recommend checking in with your local immigration community centers or local immigration services. They could have this information to help you access services that could be beneficial and valuable to you. Once you receive permanent residency, the countdown to citizenship begins. Eligibility for citizenship typically requires 3 years. That's a total of 1,095 days of physical presence in Canada within the past 5 years. Tax filing compliance as well, proof of language skills for applicants that are aged between 18 and 54, and you need to pass the citizenship test. This is for those applicants that are aged between 18 and 54 again. Protected persons who become permanent residents may apply for citizenship sooner than many realize, because I've heard some people say, oh, I heard I'm going to wait for 6 years or 5 years before I get my citizenship. Being accepted as a refugee in Canada is a profound legal and human milestone, and therefore if you're listening to this and you have been found to be a protected person or a convention refugee in Canada, congratulations. It's the gateway to permanent status, and for many a new life of freedom, safety and dignity. Make sure you make great use of this opportunity that has been granted to you by Canada. Now let's talk about the flip side of the coin. Life after a negative decision from the Refugee Protection Division. A negative decision from the Refugee Protection Division can feel devastating, but in Canadian immigration law, rejection does not always mean removal. And so I'm going to walk you through the legal options that are available to someone who has received a negative decision from the Refugee Protection Division. Now, I know that I touched on it briefly during the course of this video. However, let's take a deep dive. First, you need to understand the decision. The decision letter from the IRB will outline why your claim was refused. It will address your credibility, your evidence, and legal grounds. If the negative decision was because of no credible basis, or was based on grounds of no credible basis, then you are not eligible for an appeal. Whatever the case may be, do not panic. Read the decision carefully, then speak to a lawyer immediately. Timelines are tight, and so are your rights. You need to ensure that you speak with a lawyer as soon as possible. As mentioned earlier, you need to be eligible in order to appeal an RPD decision before the RAD. Most claimants who receive a negative IRB decision can appeal, however, not all. Claimants found ineligible cannot appeal. Claimants who withdrew or abandoned their claim cannot appeal. And designated foreign nationals cannot appeal before the RAD as well. And those who came through the US under the Safe Third Country Agreement, as well as the case may be, might not be eligible to appeal an RPD decision before the RAD. Other options include judicial review that I've already spoken about, and a PRA, that's a pre-removal risk assessment, that I've spoken about as well. And as I mentioned, the PRA assesses new evidence of risk to life, cruel and unusual treatment or torture, changes in country conditions, and new developments in your personal situation that were not taken into consideration during the Refugee Protection Division hearing. Note that not everyone is eligible for PRA right away, especially if your claim was rejected within the last 12 months. So depending on your circumstances, you might not be readily or immediately eligible for PRA or HNC or any other pathway. You need to ensure that you speak with a lawyer, and that lawyer will be able to determine which of these options or pathways could be or would be accessible to you. One important information that I need to mention is that filing an HNC application does not stop removal unless a stay or deferral of removal is granted. After a negative decision, CBSC may issue a departure order, exclusion order, or deportation order. You may be asked to voluntarily leave Canada within a set time frame, or attend an interview with a removal officer, or surrender your travel documents. You may be able to request a stay of removal from the federal court, or a deferral of removal based on pending applications or medical risk, or support from a member of parliament in rare cases. Do not wait until removal is imminent to seek help. Seek help immediately after refusal. Book a legal consultation with a lawyer, identify appeal rights and deadlines, gather new evidence if any, and discuss longer-term options like HNC or pre-removal risk assessments. Every single day counts. Stay mindful of your immigration journey. A refused refugee claim is not the end of the journey. Like I always say, it's the beginning of your legal second action. Second chances in Canadian immigration law come with tight timelines and no room for error. It could equally be very costly. Do not go silent after a negative decision. Do not go underground. Go legal immediately. I'm going to talk briefly about an Outland refugee claim. An Outland refugee claim is made by someone who is outside both of their home country and Canada, typically in a refugee camp or third country, as the case may be, where they've sought temporary safety, again, as the case may be. These individuals apply for resettlement to Canada as convention refugees, often through the United Nations High Commissioner for Refugees, which is popularly known as UNHCR, a private sponsorship group or a blended visa office referral program, popularly called BVOR. And here's how it works. The UNHCR, or a trusted referral organization, identifies the person as a refugee in need of durable settlement. Alternatively, a Canadian group or organization like a church, mosque, or a charity organization can sponsor the individual or family through a private sponsorship or refugees program. The application is processed abroad by Canadian visa officers who assess eligibility, admissibility, identity, and documentation. And if approved, the refugee arrives in Canada as a permanent resident with access to healthcare, resettlement services, and the opportunity to build a new life with peace, safety, and dignity. Outland claims are typically reserved for those who cannot safely return to their home country and cannot safely remain where they currently are. It is a long and selective process, and often involving intense security screenings and very long waits. It is a life-saving alternative for those who cannot make it to Canada on their own. Canada equally offers opportunities of protection to people who are outside of Canada. If you'd like to know more or specific details about the Outland refugee claim, let me know in the comments. And if I have sufficient demand for that information, I can equally create a detailed step-by-step process type of video for an Outland refugee claim. If you've watched this video up until this point and you are in the process or supported someone who is, or simply seeking to understand it all, thank you for being here. Thank you for your time and your attention. Here's what I want every refugee claimant to take away from this. So this is your bonus for making it up until this point. I'm going to share these very important nuggets with you, just so you keep it in mind for your awareness, for your information, and just in case you are in the process or you know someone who is, this could be helpful information. 1. This process is not easy, but it is navigable. Canadian immigration law is layered, complex, and quite strategic. 2. Legal representation is not just a benefit, it is a lifeline. Would you walk into a criminal trial without a lawyer? The answer is no, right? So don't try it in a refugee claim. You should not walk into a refugee hearing without a lawyer. Refugee protection is a matter of law, not just emotion. Legal counsel helps you present your case in a clear, credible, and complete manner. Legal counsel also helps protect your rights, especially if things go wrong. 3. Timelines are not suggestions, they are legal deadlines. One late submission or one missed appointment, one unopened letter, and your claim could be deemed abandoned, your rights extinguished, and your future in Canada compromised. Track every date, stay in touch with your lawyer, check your mail and email daily or as often as possible. 4. Honesty and consistency are your greatest assets. The IRB wants to know who you are, what happened to you, and why you're afraid to go home. You need to tell your story fully, truthfully, and consistently. If something is missing, explain why. If something is difficult to locate or to find, say so, explain why. The truth, when well presented, is your greatest protection. 5. Healing. Healing is also part of the process. Many refugee claimants carry trauma, loss, and exhaustion with them. I've sat across from clients whose eyes held stories that their mouths could barely tell. The entire refugee claim process could be legal, but I understand that it's also human. Take some time to process everything that you've been through and heal. 6. Keep learning, keep asking, keep going, just keep walking. If you're watching this video, it means you're already ahead, meaning that you're actually trying to know more about this process, or you're trying to learn more about this process, which is great. Just continue. Stay informed, ask questions, seek clarity. And one thing, Never assume that what worked for one person will work for you. Your claim is unique. If you need help or if you need guidance through your refugee claim in Canada, whether you're at the start of the process, midway, or post refusal, or post acceptance actually as well, I invite you to book a legal consultation with me, your trusted Canadian immigration lawyer, and I'll be more than happy to assist. I do assist with the review of applications and submission of PR applications as well, post a positive decision. And post negative decisions, I do assist with judicial reviews, appeal before the RAD, PRA applications, HNC applications, whichever pathway that could be suitable for your circumstances. We can discuss all of those during the legal consultation. To book your legal consultation, you just need to click on the link in the description. If you made it to this point of this video, thank you so much for coming along. Don't forget to like, share, and subscribe to Briefs and Balance for more insights into Canadian immigration. Until next time, I am Lily, your trusted Canadian immigration lawyer. Thank you for tuning in today. Stay informed, stay inspired, and stay purposeful. And remember, you are God's masterpiece. See you next time.